been a very hectic year, and it's only February. International law kind of sits at the crossroads of foreign affairs and law, which is why it's perfect for a show called Between Parks Place and Capitol Hill. And joining us to discuss this increasing polarization and radicalism, in a sense, as well, and what it means to the stability of this international system is Dr. Juliette McIntyre of the University of South Australia. Thanks for joining us for this one.
Thank you for having me.
I guess to start with, what exactly are international norms, and did they affect anything in NZYQ at all with regards to how we treat refugees and detainees and migration?
Yeah, so the way I usually describe it is that there's sort of two layers of law you can think of. There's the international layer and then there's the domestic layer. And they do interact quite a lot, but the foundational principle of the international legal order is that states are sovereign and equal. So that means within any given country, the state is in charge of making its own laws, deciding how it wants to govern itself. I mean, that's pretty obvious when you look around the world, right? Everyone's got a different way of doing things, different laws, and so on. So that's part one. In Australia, we subscribe to a system. It's not a system, it's not a formal thing, but we describe it as being dualist. And so what that means is that the approach of Australian legal systems, our parliament, our courts and so on, is to treat international law as quite a separate system. And they'll only integrate laws from that system once they've been run through the domestic system. So, for example, let's take a treaty that's sitting at the international level. So that's an agreement between two states or more states about any given topic. In this case, it would be the Refugees Convention. So that convention governs the treatment of refugees. It was created in the aftermath of World War II to obviously offer protection to people who have been displaced by massive, conflict and so on. So it has obligations for states that have signed up to those to that treaty, have become a party to that treaty, and Australia is a party. But when it comes to our domestic law and the High Court and interpreting the Constitution, all that sort of stuff, what they'll look at is whether or not the government has actually implemented those obligations into our domestic law. Now, in this case, the government actually has to a certain extent, and they've actually reduced the amount that they've done it over the years. So initially in the Migration Act, it used to just say, the Refugees Convention is adopted into Australian law, basically, and all of the protections that are offered to refugees under that convention become part of Australian law. This included things like, for example, the definition of who is a refugee. Over the years, the Australian government has reduced those protections, including things like removing those references to the Refugee Convention. There's little bits that are still in the Migration Act, but for example, the definition of refugee has been changed to an Australian version of who is a refugee. So Australia is still a party to that convention. On the international level, we still have all of those obligations. So for example, if another country was bothered or upset by our treatment of refugees, they may have options at the international level to try and enforce our obligations. But at the domestic level, as I said, High Court doesn't have to take that into account. What it's going to look primarily at is Australian domestic law and what those acts, what that legislation says. So I know there's a very long explanation, but as I said, it's quite a complicated iterative relationship there between the two.
Yeah, I mean, we've covered the external affairs power pretty extensively, or at least Aidan has. Tasmanian Dam's case, we've been all over that. So I'm sure Aidan can talk about that for an hour if I let him. That's his area. But I guess on that, we have obviously we've got statutory law and common law as well. International norms versus treaties. Is it the same sort of division you have there? Norms and the norms being common law. Is that an accurate comparison? Yeah. Just before we get into the politics of it as well.
Yeah, absolutely. So the way that we categorize the different types of law at the international level is there's treaties, which are kind of, you can think of them like contracts, really. They're agreements between states to do certain things. Then you've got what is called customary international law. Now, customary international law is law that has usually been in existence for a long period of time. And there needs to be two things for custom to come into existence. There needs to be state practice, that is, countries need to be doing a certain thing. And there needs to be something else, which we use Latin, it's opinio juris. It basically means a belief that the thing that you're doing is required by law. So there needs to be this combination of practice and belief, and then you have a custom that is a legal custom. Either of those can be described as norms. The word norms doesn't have a standalone characteristic. Really, norms just means legal obligations, or the way that it's often used in our language. So those are the two main sources of international law proper. And then we have things like judicial decisions from the International Court of Justice. Those can't make law, but of course they will interpret law and they will guide states on what their obligations are. So we don't have a common law-like system where there is precedent and obligation flowing from judicial decisions. But just because a court has ruled on what the interpretation is, obviously that has a certain normative value that's just going to, become the standard practice, right? So even though judicial decisions are not a main source of law, they're considered a subsidiary source of law in that sense. And then we also have something called general principles, which pretty much no one talks about because it's more like technical little things about how courts might operate. Basically looking around at domestic systems and going, oh, that's a good idea, we might adopt that one. So treaties and customary law are two main sources of international law.
I'm glad you mentioned the International Court of Justice because we'll go into that in just a little bit, but I just want to sort of look at it from a broader perspective for our audience before we get there. And you mentioned with international law in Australia, it's sort of a twofold process because you've got domestic obligations and then you've got our international obligations. And obviously, as you said, the High Court's not going to be hearing cases about Australia not following certain treaties. So I was going to ask, before we look specifically at the ICJ, ICC, any of that stuff, but how can those international laws, how can our global obligations actually be enforced on a foreign stage? Because we've seen, throughout even just recent history with the Russia-Ukrainian war, a lot of, talks about international law, a lot of talks about obligations not being fulfilled and then nothing can really be done about it. Is that true or is it more complicated than that?
Well, it's of course more complicated than that, but I do appreciate that it does look for the average punter sometimes like none of this gets enforced, right? But there's several different mechanisms out there for enforcement. So one of them, if you take human rights treaties, for example, there's several human rights treaties that are in existence, and those treaties often have bodies attached to them that are empowered to rule on whether states are complying with their obligations or not. And people who believe that their human rights have been breached can bring an action directly in that body. So there are some famous Australian cases. There's a Tunin case, which is a famous case about from Tasmania, about privacy and the right to privacy. And I won't give you the whole background of the case, but anyway, there's a number of sort of quite famous cases in these bodies that have come out of Australia. So there are enforcement mechanisms that exist for individuals. And then at the state to state level, of course, we've got places like the International Court of Justice where a state can pursue a case if they consider that the obligations aren't being met. But then there's a whole bunch of other stuff that can happen as well outside of a courtroom. So states who believe that another state is not upholding their obligations can, for example, raise it at the UN General Assembly. If they're on the Security Council, or they can petition the Security Council, they can raise it at the UN Security Council. Or they can just take measures into their own hands, because as I said at the start, all states are sovereign and equal. So there are things called countermeasures where states can put in place sanctions and all these other types of ways of putting pressure on a state to comply with their legal obligations. So there's lots of stuff that happens in the background that doesn't necessarily make front page news where international law is being enforced.
Casting my mind back to university, I recall one of my lecturers saying most international laws are followed by most countries most of the time. The fact that they make the news is because if they were always being breached all the time, you would never hear them in the news. We treat it as pretty normal, pretty status quo. But the fact that they are such big stories kind of demonstrates a bit that they are extraordinary events. But I'm glad you mentioned the UN Security Council because that's our first issue here. Populism is on the rise. You've got Trump in the US and you've got Putin in Russia, and they're two of the five. Also you've got Communist China as well. So that's three of your five of the people with or the states with the veto power on the UN Security Council. So that's probably the first place I want to start with here. Looking at whether you want to talk about it with Israel or with Ukraine or anything like that. There's kind of a pressure internally in, say, the US in particular, for example, where you have this sort of polarized system, and that in turn then drives policy. So would it be argued potentially that this veto power is kind of able to be, or at least the leverage that it implies, can kind of be used at whim by certain actors? In a way, whether it be for Ukraine or Israel or anything else, these sort of, like, can you call them bullies in a way compared to other countries? That's probably the first issue I want to touch on here. Is that much of an issue when you're talking about populism? And of course, we're going to go into Trump in a second, but would that be part of the issue we're talking about here?
Yeah, definitely. So the veto power that the P5, the permanent five members of the Security Council has, is a persistent problem for the enforcement of international law. It's a regular stumbling block. So the thing to keep in the back of your mind is that the Security Council was created by the people who won the Second World War. And this veto power was very controversial. In fact, there was an Australian diplomat, Doc Evatt, who fought really hard against it because I guess he could kind of see the obvious result, right? Which is what we currently have, this stalemate when it comes to self-interest from these powerful states. However, these states were very powerful at the time. They were the victors of World War II. They had led this victory. And so they wanted to maintain their power. The reality is that this sort of emperor-like power was baked in from the start. The idea behind it was somewhat noble, insofar as you didn't want states going around using force against other states ever again. That was the whole point of this structure that was created, was that World War II was so destructive and so terrible that they said, never again. Well, that was the Genocide Convention, but we can get onto that in a second. But, this kind of thing could never happen again. And so we needed to create a blanket rule that the use of force was absolutely unlawful. And that is put into the UN Charter, Article 2.4. The use of force is forbidden, except in two very exceptional circumstances. One is self-defense, and the other one is with imprimatur of the Security Council. And so the idea behind having this P5 veto power was that you would prevent states from gathering up their mates and going around and invading other countries. If you could get Russia, China, the US to agree that using force was a good thing, then probably it was a good thing, right? If it's so obvious to these three states who can't agree on anything, then sure, you should definitely go ahead. Well, it was the USSR at the time, of course. Yes, however, the problem has now come very obviously in the last couple of years that when these states are self-interested in these issues, when it's Russia who's doing the invading, when it's Israel who the US protects under all circumstances, vetoes every single resolution, bar a couple of very middling ones at the UN Security Council, when they've got their own, I'm running out of metaphors, but when they've got their own skin in the game, right, they are not going to vote in the global interest. They're going to vote in the self-interest. And we can't get around this problem. It has crippled the Security Council in respect of the Ukraine one's an interesting one, right? Because pretty much everyone else was completely in agreement that what Russia was doing was absolutely unlawful. And the Security Council would 100% probably have authorized a use of force if that was the path they decided to go down, except for the Russian veto, right? But you also can't order anything else. You can't order compulsory sanctions. You can't order, other types of measures that might help to reduce the scale of the conflict. Once the P5 decide to vote against it, that's it for anything, not just the use of force. So yeah, it has been really crippling. And then again, of course, we've seen it in Gaza with Israel. There's no getting around it. unfortunately. There is simply no getting around it without just dismantling the whole structure and starting again, because it's baked into the UN Charter. And the only way to reform the Security Council is to have the agreement of all of the P5. And that's never going to happen.
I mean, the two exceptions there being Korea, where the USSR was protesting, so it wasn't there when the Security Council voted on it, and then of course the Suez Canal crisis in the 50s, where you had Egypt backed by America and by the USSR, and Israel being involved there with the UK, and frankly, kind of a reverse role to what they are right now.
Mm. Yeah. I mean, it's not that it always fails, right? I mean, it does do quite a lot of stuff, just not in respect of usually the P5's own interests. That's sort of, Libya, for example, in 2011, the Security Council authorized the use of force against Gaddafi. So it's not that it always fails. It's just that it 99.9% of the time fails when one of the P5's own interests are involved.
I want to then go to sort of the public perception of it, because I know we did the sovereign citizen episode, but a lot of what we do at GovCheck is about trying to engage an audience. And, something that's quite clear with the law is that the average person is quite far removed from what's actually going on in the law. And I almost think it extends even further to this, where a lot of people in the legal field, even them, they can study international, they can write about international law, but, remember, like Australia's representative to the United Nations is not democratically elected. There's not really much of a way for even the average legal person to get involved in it. And with the veto power and the self-interest of the P5 states, how has that sort of developed to sort of maybe a public distrust in the law? And as you said, there's no way of sort of removing it unless all the P5 nations agree, which will never happen. But then how can we navigate an international law system in this sort of reality that we live in, and reality that we know we can't change, but what can be done to not only improve public perception of what's going on, but also improve the legal and technical side of things?
Yeah, so I think there's a couple of factors there. I mean, education, knowledge is power, right? So I think understanding that, going back to what Stuart said at the beginning, that's actually a really famous quote in international law from a man called Louis Henkin. International law is followed by most states most of the time. And that is true. And I think what people need to do, and what I usually get, say, my students to do, is look around and say, okay, who's taken an international flight recently? Who has a passport? Who has a package delivered from Amazon recently? We have huge systems and structures that are governed by international law that just function so smoothly that we don't even notice their existence. And so I think paying attention to their existence restores a little bit of faith in the system to start with, because we go, okay, actually, the fact that airplanes can fly from country to country almost never with an incident, the fact that we can get on those planes and off those planes and have a regulated system of travel from one country to another across borders, the fact that we can get our Amazon packages. The oldest international organization in the world is the Universal Postal Union. So these things, I think, demonstrate that at its core, there's a real core of functionality for international law that exists. The law of the sea. Yes, there are disputes about it, but it also governs, maritime shipping and the way that, boats travel around the place, undersea cable communications, all of this stuff that underpins modern daily life is governed by international treaties. So I think when we look at that, we can reassure ourselves a little bit to say, actually, mostly the system is working. And what draws our attention are these massive conflicts. And like massive conflicts in just about any kind of situation, they will, cause anxiety about whether the system as a whole is working, but they are unusual. And they are exceptions to the overall structure. They're not necessarily the norm. The problem is that we can't seem to fix the system sufficiently to deal with those exceptions. And I think that's where it becomes different, because in a domestic system, it's a bit of a grim example, but let's take the Port Arthur massacre. You had a really exceptional breach of norms there. So, it was an unbelievable act of terrorism, and so many people lost their lives. We were able to act then to change the system, to change the gun laws, to prevent that from happening again. What we are lacking in the international system is the power to change this bit of the system that is not working to prevent it from happening again. So I hope that sort of makes sense, because yeah, it is one of those things that draws your attention, right? When there are genocides occurring, and you think, why can't people do something about this? And it's appalling to watch, and it really, you do start to lose faith in law's ability to govern in these situations. But yeah, that's the difference, really. In the domestic system, we have the power to change the system, whereas in the international system, some of these things are really baked in, and we can't change them.
I do want to talk about change just one more final time quickly, because Israel and Gaza is quite a controversial topic, and you've obviously mentioned it already previously. But even with the US being able to veto certain resolutions, they were pushing quite publicly for a ceasefire in Gaza. And that's obviously after, many months of fighting has amounted. So just before we finish up, what lessons can we sort of take from not just a activist, media, all the people coming together, but from a legal perspective, what lessons can we take? Because the UN was pushing for that. Well, a lot of the states were pushing for that for quite a long time. And even if the resolutions themselves, passed with massive majorities, nothing could ever be done from a very technical side. But are there any lessons that we can take by the use of international law in order to force an outcome like we've just seen?
Yeah. So the Israel situation there's a lot of overlapping law in relation to that system. We're all, of course, familiar with the case that's been brought by South Africa under the Genocide Convention alleging genocide against Israel. But there's a whole host of other laws that govern the conduct of armed conflict, and questions about whether those laws were breached or who they were breached by. And then, of course, there's the international criminal law side, where individuals may have committed crimes against humanity or war crimes on both Hamas with the hostages initially and then Israel afterwards. So how, what can the law do in this situation? The answer is a lot and not a lot. The law provides the background for the negotiations that have to take place in these kinds of situations. And it sits there and provides the framework, if you will. So we can make assessments about the illegality of certain conduct on the part of Israel, for example, and the ICC and the International Court of Justice will make that assessment in due course. But in the meantime, states are watching this conduct, they are reaching their own decisions about its legality or illegality, and then they're using those decisions to inform the way that they go about either pressuring negotiations, acting within negotiations if they're present in the room, whether they make statements in the media, whether they take other external actions to show support or validation. The law justifies the conduct on behalf of those other states. It doesn't just tell the protagonists what it is that they can and cannot do, but it provides the ground for other states to get involved and a reason to get involved. So take genocide, for example. There is an obligation on all states parties to the Genocide Convention to act to prevent genocide. And so as soon as the International Court of Justice said in its provisional measures decision that there was a possibility of genocide occurring here, no decision that it has, but that it might be happening, then that places the onus on all states parties to the Genocide Convention, which is pretty much everybody, to do what they can to add pressure to the situation to stop it. And so that's what the law does. It offers this framework and this background. You can't necessarily legislate your way out of conflict, right? You need to negotiate, but the law provides that framing and that background, and as I said, that justification and the reason for doing something.
Probably just before we wrap up here, I want to kind of do a two-in-one question. When you think about like the League of Nations, everyone points to Australia politically, and I'm reminded now of Trump trying to annex Greenland, and of course Trump leaving WHO as well of his own free will, which raises a whole other set of questions. But I remembered of the League of Nations in the 1920s. They failed to stop France invading the Ruhr, for example, which was done to enforce German reparation payments from World War One without the League's support. But at the same time, there's a political failure, which is what we're seeing right now in many areas, because the world's increasingly polarized in terms of politics, especially in the US, where they've only got two parties. But I guess what I'm getting at is that at the same time as that failing, the social, the economic aspect of it went really well. There are a lot of aid operations carried out by the League of Nations before it kind of collapsed in the 30s. The issue, yeah, I guess was funding, and do we have the same sort of issue now? Probably as a final point is how do politics affect how the funding of the UN or of any other bodies are, and how does this affect our ability to act in peacekeeping roles in terms of funding for aid and such?
Yeah, so funding is a massive one. And it's the reason that the US withdrawing from WHO is so concerning, for example, because they provide a huge portion of the funding to a number of these bodies because they have the largest economy in the world. So it is concerning. Another example is the UN Refugee Agency in Gaza, when a lot of states stopped funding that body as a result of accusations that there were links with Hamas. So yeah, funding is a huge portion of, funding, of course, gives these organizations the ability to do their work. And that work might be development work, as you said, work might be aid work, it's rebuilding work after a conflict and all these sorts of things, or the protection of civilians in wartime. Where we see that funding being withdrawn, the possibilities of that work going ahead are massively reduced. But I guess you work with what you've got, right? If the US chooses to withdraw because of the perceptions of the international order that are coming from the domestic level in the US, then other states have to step up and carry on without them. And sometimes that can be difficult, or other times it can almost be a net positive. I mean, Trump has also withdrawn from the Paris Agreement, and while the US is, the largest emitter, and them not being on board with climate change treaties that create obligations to stop polluting the environment is a bad thing, it also kind of gets them out of the way. They're not going to be in the room with the negotiations, and they're not going to be obstructing things, and other states can actually just carry on and reach an agreement. There are 194 states in the world, 195 maybe. Someone's going to write in and tell me I've got it wrong. Could be 196. I've completely forgotten. But there's a lot. We don't have to continually rely on one state, that is the US, being the leader of the free world and only, kind of following what they do or waiting for them to do stuff. Everyone else can get together and start running the show. And I think that's probably what we might see, more of that approach as we go forward into the Trump administration years, because we're starting to see an increase in states exercising those powers. You've got the Gambia bringing an action against Myanmar. You've got South Africa bringing the Israel case, of course. So states who traditionally don't lead in these roles stepping into those leadership positions. And yeah, while there may not be as much funding, these states can work with, as I said, work with what they've got. And if the US chooses to withdraw itself completely and isolate from this process, well, so be it. I think there's certain things that we just have to get on with, even if they choose not to be at the table.
Well, you've heard it from us first. The solution to world peace is give more money to the UN. Thank you thank you for giving us your time and coming on to help us with discussing this issue, which I'm sure is going to be in everyone's minds over the coming weeks and coming months. And thanks everyone for watching.
Thank you.